The next paper is by Fred. It talks about economic conditions that drive lending to debtors in possession. This is, I think, especially interesting for India because India happens to be one of the few countries which has moved away from the debtor in possession model in insolvency. So what are the implications of this, etc.? I think that will be fairly interesting to the audience here. Fred? Oh. Yeah, it's all yours.
So I realize I'm in the lonely position of standing between you and lunch. So I have a bit of an involved paper, but I'll just try to hit the highlights so we can sort of try to keep to our schedule. So my name is Fred Tung. I'm a law professor at Boston University School of Law. And the title of my paper is, Do Economic Conditions Drive DIP Lending? Evidence from the Financial Crisis. So in the US, whenever a large public company goes into bankruptcy, typically it requires financing in order to operate while the restructuring is being negotiated. I look at particular terms of DIP loan agreements with some objections to the way that some of them are structured. So in particular, I look at what in the US we call extraordinary provisions in DIP loans, which are essentially aggressive lender protective features that judges were approving in the aftermath of the financial crisis. And they were largely approving these aggressive lender protective features with the rationale that post-crisis, the credit markets are too tight, so we have to give the lenders what they want in order for the company to survive. Now, let me emphasize, I am not criticizing the judges on having to make these hard decisions. It's a sort of a tricky position for a judge to be in, because essentially, by the time the financing comes to the court, there's really only one deal on the table. So the judge can sort of tinker with the terms at the margin, but as a practical matter, the judge can't really deny the loan because of the risk of liquidation if the company doesn't get the financing. Okay, so what do? I look at both extraordinary provisions, which I'll describe in a minute, and also ordinary provisions, in this case, DIP loan pricing and covenants. And the question is, can we explain the structure of these provisions by reference to credit scarcity? Okay. Happily, the financial crisis gave us a nice shock to credit markets so that we get to see both feast and famine in the credit markets in a pretty short time span. So let me just talk about the DIP loan terms that we're going to focus on. Ordinary provisions, pricing, and loan covenants, and then we'll look at extraordinary provisions as well. Pricing, we're going to look at all-in spread. Loan covenants, we're going to look at reporting covenants. In particular, as you'll see, the two most common covenants in our sample are two types of reporting covenants. Essentially, periodic updates to the lender about the financial condition of the company during the course of the case. The first is cash reporting. How is the company spending its cash? And the second is budget reporting. Again, the two most common covenants across our sample. Now, extraordinary provisions, again, we'll look at two. One is called roll-ups, and the other milestones. Now, what's a roll-up? So a roll-up is a contractual provision in the DIP loan that requires the debtor to draw down on the DIP loan to repay the pre-bankruptcy secured lender's pre-bankruptcy claim. And typically, again, in big public company cases in the US, the most common DIP lender happens to be the company's pre-bankruptcy lender. And so the provision in the agreement basically says, we want you to refinance. We, the lender, want the borrower to refinance the pre-bankruptcy claim with the DIP loan. Now, why is that a problem? Ordinarily, claims get paid only once the case is over. But here with roll-ups, the pre-bankruptcy claim gets cashed out essentially early on in the case. So some specific problems, what the roll-up does is it cashes out the pre-bankruptcy claim with sure to be repaid DIP lending. DIP loans almost literally never default in the US. Potential bad consequences, whoops. Number one, once the pre-bankruptcy secured lender's claim is paid off, it has no more reorganization risk on that claim. In addition, once you've cashed out the pre-bankruptcy claim, you can't have a plan that pays off that claim with promises because you've already used cash to pay it off. The company will have a larger exit financing burden. Typically, when a company comes out of bankruptcy, it has to get another loan as well to refinance the DIP loan to come out and operate post-confirmation. And finally, all of this, of course, may take value from junior claimants because they're the ones at the bottom of the pile who end up with whatever's left over. Okay, that's roll-ups. What are milestones? Milestones are pretty simple. They're just deadlines that the creditor imposes on the company relating to things like the filing or court approval of a plan of reorganization or a disclosure statement. The other kind of milestone we find is requirements for court approval or completion of major asset sales. All right, so let me just, to relieve you of your suspense, let me just tell you what the results look like. For pricing, it turns out that pricing works the way we think it does. With credit scarcity, pricing increases. With loan covenants, with credit scarcity, loan covenants become more stringent. For both budget and cash reporting, the frequency of reporting gets stricter as credit becomes more scarce. On the other hand, for the extraordinary provisions, it turns out that they bore no relation to credit availability. And remember, the reason that the extraordinary provisions, we call them extraordinary, is because by and large, so they're not explicitly authorized in the menu of goodies that courts are able to offer lenders to induce their lending. And arguably, they are inconsistent with other provisions in the bankruptcy code. Right, so data we get from Linlow-Puckey's database, and our sample period is 2004 to 2012. Case files come from Pacer. We do a lot of hand coding on the DIP loan agreements themselves. We look at the covenants and other loan terms like the total DIP amount and the case milestones. And also, of course, all the terms surrounding the roll-up. For all-in spread, we get that from Thomson Reuters. And for domestic credit level, we get it mainly from the Bank of International Settlements. Okay, just some background information on the sample. 288 cases, 182 or over 60% have DIP loans. Just about every DIP loan has a cash reporting covenant and a budget reporting covenant. About a little over half of our DIP loans have roll-ups. A third have reorganization milestones, and a relative handful, about 15%, have sale milestones. Okay, this is our main measure of credit scarcity. It's quarterly change in credit supply in the US, excluding financial firms. And we can see when we look at this curve, it pretty well tracks the up and down of the financial crisis. So remember, it was in '06 that a lot of the subprime mortgages began to default. And then in '07, mortgage-backed securities market got soft. And then things got really bad. In early '08, Bear Stearns fails and has to get sold to JP Morgan. And then remember that crazy 10 days in September when Lehman Brothers files for bankruptcy. And AIG fails, and the government's got to put in several billion in credit. And the government takes over Fannie Mae and Freddie Mac. So we see this big drop in credit availability. And then after sort of the late '09, early 2010, the credit markets recovered. All right, so let's take a look at the incidence of DIP loans in our sample. Just look at the red curve. You can see the resemblance between the red curve and the credit availability curve that we looked at. Basically, credit becomes scarcer as we get around the financial crisis in 08, 09, 2010. In the early part of the period, something like 85 to 95% of the cases all have DIP loans. It gets tougher as we get into the crisis, and then it recovers after 2010. Okay, I'm going to blow through some of these slides since I'm almost out of time. So this is simply all I've done now is put this blue line, which is all-in spread, up against our credit availability. And you see, generally speaking, it's inversely, the blue line is inversely related to the red line. If we look at loan pricing, we do some quick regressions, and we see that the result is what we expect, that as credit gets scarcer, DIP loan pricing goes up. It moves inversely with the supply of credit. So our first ordinary provision works the way we think it would. The second one, reporting covenants. Let me just show you these two quick pictures. The purple line here describes more stringent reporting covenants. So with our reporting covenants, two basic, the most common flavors are weekly reporting and monthly reporting. The purple line describes the incidence of the more stringent reporting, which is the weekly reporting. If you just look in the middle of the picture around the big column of cases in 2009, you see this inverted U shape in both of them. That essentially tells us that as the crisis got worse and credit scarcity got worse, there was more stringent use of reporting covenants. And we see that outside of that inverted U, we have sort of more relaxed reporting. We do a regression. We just, without going into the details of the regression, let me just say that the results are consistent with those graphs, that the stringency of reporting requirements also varies with credit scarcity the way we think it should. Okay, let's talk about the extraordinary provisions. So this is so look at the green line. The green line describes the percentage of cases in a given year that have roll-ups. Now, unlike the other lines we saw where we have this inverted U shape around the financial crisis, we have the opposite sort of graph here, where it turns out that we would have expected, if the rationale were credit scarce, we have to give the lenders what they want. We would have expected that we'd have a much higher incidence of roll-ups around 2009 and lower incidence of roll-ups in other years. It turns out, however, this little dip in 2009, that is the year with the lowest percentage of roll-ups. It was higher in every other year. So it would lead us to question whether or not this rationale of credit scarcity is what's driving the incidence of roll-ups. Do a regression, and it confirms four different measures of roll-ups. We don't see any statistical significance in any of these regressions. Now, I think it's fair to say that we don't want to read too much into getting null results in these regressions. On the other hand, when we look at the ordinary provisions, we do see that the data have enough power for us to see a statistically significant relation between the ordinary provisions and credit scarcity, but we don't see it in the roll-ups. With the milestones as well, just do a simple correlation, we get no statistical significance. When we do formal regression, same thing, we don't get any statistical significance in that test either. Okay, so the punchline between you and lunch. Ordinary loan terms respond the way we think they should. They respond to economic conditions. So DIP loan pricing and reporting frequencies increase with credit scarcity. With the extraordinary provisions, we don't see an incidence of reaction in the incidence of extraordinary provisions to the credit scarcity. So we have no evidence to support the credit market rationale for the use of extraordinary provisions. We conjecture that it may be that by the time the financial crisis started, roll-ups and milestones were already part of the status quo that judges were using to approve loans, so that it turns out that they were already part of the status quo by the time the, the financial crisis started. With that, I'll sit down and wait for your questions and comments.
Good afternoon, everyone. First of all, I thank the author. It's a very nicely written paper, and it's an empirical work. Since I'm not a lawyer, I'm an economist, so this is my personal disclaimer. I have very limited knowledge of law, and so my comments will be a little towards the empirical analysis than towards the legal side of the paper. So in summary, this is what the paper does. The paper analyzes the relationship between economic conditions and DIP loan terms. When they talk about DIP loan terms, they have 4 specific things in mind. The 2 which are the normal covenants, and then there are roll-ups and milestones. For them, the roll-ups and milestones matter because these are the extraordinary instruments which are used in times of crisis. They make a point that this is not normal. People justify their use because there is a serious credit crunch in 2008 to 2010. But if you look or if you remember from the graph, DIP roll-ups and milestones are actually used starting 2002 onwards. So even in their graph, there is more than 80% of the loans already have uses of roll-ups and milestone. Their major findings are the loan pricing and reporting covenants are actually sensitive to economic conditions, but they don't find any relationship between economic conditions and roll-up or milestones. The policy implication which they derive is that extraordinary inducement, which are in the form of roll-ups and milestones, which are often justified as necessary on grounds of economic conditions, might not be necessary. So the whole idea basically rests on a single fact, which is they run a linear regression, which is the relationship between economic conditions or the credit crunch against what are the different covenants in the loan pricing. Okay? So I have certain classification questions which I would like the authors to answer. The first one is, if you think about a roll-up or a milestone, it does not actually fundamentally change the structure of financing. What is happening is, if I have given you $50 as senior creditor, I'm giving you 50 plus 20 more to pay back my $50, and you're giving me $20 extra as operational creditor. What actually I'm gaining is only a seniority in my status. So I'm actually providing extra loan. I'm actually putting my skin in the game again with more funds. So I'm not very sure how exactly it will change the structure. If you want to prove something, I think the better idea will be, out of 300 cases, you have something like 110 cases for which there is no DIP loans. In that case, I would like to know what happened to the bankruptcy process. If it is restructured, then somehow you need to prove me that the asset value which is recovered by the junior creditor is actually higher than the asset value which is recovered in case of these DIP loans. So there at least must be a table which shows the liquidation value and the asset value recovered by the junior creditors. Then what justifies the need for this kind of intervention? There are 2 facts which is very well stated in the paper. One is that the debtor and the prospective DIP lenders typically agrees to the terms. So the debtor always has an option to not to agree with the DIP lender. And second, that we observe near zero default rate for the DIP loans. Both these statements points out that the debtor is there for a reason, and I don't see a reason why it should be against the debtor. Okay. So I don't see a claim that what's the harm to the debtor. Now, based on the empirical analysis which you have done, I have 2 questions. One is related to the measure of the available credit. You are using available credit as the credit available to non-financial corporations. This is actually the net credit demand which is coming under these economic conditions from the market players. So this actually is conditional on the economic conditions. Okay? So you need to separate this available credit from the economic conditions, because this is already conditional, preconditioned on the economic conditions available in the market. In my opinion, there is a better way to measure this available credit, which must be accounted for by the liquidity conditions in the market. So one way to look at it is the availability of credit, which can be measured by a simple benchmark key interest rate, something like LIBOR or YS spread or something like that. And the second will be a risk premium, which will come because of the uncertainty in the market. So this can be something like the spread between investment and speculative grade bonds.
I should have been clear that the numbers we use in all-in spread are at the margin of the LIBOR.
Okay, but I think LIBOR should also be there because the benchmark or the basic risk-free rate actually matters as a liquidity condition. So I think there should be two terms. One has to be related to the benchmark, the basic level of risk-free rate which is available in the market. And the second should be related to the risk premium, which people are charging above this. So something like a volatility index or a spread between investment and speculative grade bonds will be great. Thank you, that's all.
Thanks, Manish. All right, so it looks like my saving strategy has just paid off, and I've been allowed to give each of the authors 5 minutes to respond to the comments, and if there's time left, maybe just some quick questions as well. So, Anthony, do you want to respond to Pratik's comments or take questions? However.
The response was great. One thing to clarify, the side agreements do serve a positive purpose in the U.S. system, and I think the same one you were talking about in the Indian system is to keep one party from either liquidating when they shouldn't or reorganizing when they shouldn't. And I think the main way to think of what the first is, the first lien creditor is requiring the junior to promise not to force a reorganization when it's inefficient, because they're worried about the reorganization bias. Now, you were saying in the Indian system there's a liquidation bias, and so you could have the agreement do the opposite. But that's the same fundamental purpose. The question then is, it's any classic hold-up problem. You have a contract to stop one side from holding up, and then it flips the hold-up to the other side. And so I think the solution would be the same, as you'd want to allow the agreements, you'd want to enforce them, but you'd want to enforce them for expectation damage rather than specifically. And then you'd worry, and rather than stipulated damages, because that's a way to extract value from the parties not at the table. So that's the response. Other than that, I would love to take questions.
We have time for about 2 quick questions. Do you want to go first?
I'll make it a very quick question. So, are you able to, your proposed scheme, are you able to accomplish, in a way, state contingent, the judges to effectively implement a state contingent scheme? Is that what gives you the optimality, or it wasn't completely clear?
Yeah, so no, it's not. The idea is we don't want it to be, it can't be state contingent. We're assuming that your contract can't define the state well enough for a judge to know. So the assumption is whether you're in the good or bad state is too hard for the judge to define, because in reality there's like 10 different states, right? And so our point is we want to get the best system in where we can't contract over the state. No system is going to be perfect. And so our proposal is the system that the only error you're going to get is the junior sometimes too often asserting their rights in bankruptcy, which means a DIP loan is proposed that's a bad DIP loan. But there, the judge sees the loan and says, well, this is bad for the unsecured creditors. That's not a perfect system, but it's better than the world where a good loan is never proposed and the judge can't rule on it at all, and no one even knows that it exists. That's the kind of second best world we end up in, is the only error that remains is too much activity by the junior.
All right. I'll just collect questions from Venki and Yasha and then request Anthony to respond.
I don't know whether you covered this. If there is a market for these loans, will this affect in the sense that you could have a side agreement and then maybe get out of the contract by selling it out? What happens?
I'll just collect the question. Yasha.
Great presentations in this session. I just wanted to ask Tony as well, to what extent do you see valuation disputes as potentially problematic in this? I mean, we see that in the case of Cramdown, for example, Rash, Till, whatever. To what extent are valuation disputes likely to create a friction in the proposal that you have?
All right, so easy question, hard question. The agreements are tradable. You can trade your position in it, but you can't get out of the terms of the agreement. So like a second lien might be syndicated, but the administrative agent will be bound by the terms no matter who holds the positions in the syndicate. So you can't get out of the agreement by selling if you sell your position to someone else, they're bound just like you are. So it transfers. Valuation's a huge issue with all of this. So we've assumed unbiased but not perfect valuation of the damages to get our proposal. If damages are biased, then you have to account for that. They can be inaccurate as long as they're unbiased. You're going to get the right expected outcome. But if you have bias and damages, like with anything, the valuation that ruins the solution.
Fred, you have 5 minutes to respond to Pratik, and then we can take questions.
Manish, thank you very much for your comments. I think the idea of comparing the DIP loan cases without roll-ups to the ones with roll-ups is an interesting idea. I'm a little worried about how to figure out how to compare apples to apples. There's going to be endogeneity issues there. Besides that, wonderful comments, and I'm happy to field any questions.
Do we have any questions?
A quick question. Is the roll-ups weakening or strengthening the super priority status of the?
Better. The DIP loan that refinances the pre-bankruptcy loan gets, it basically has to get paid out.
But only for the existing lender. What if the DIP loan financier is not an existing lender?
Oh, then there's not going to be a roll-up because it won't be their claim it won't be their pre-bankruptcy claim that they try to
Yeah,
to
then
cash out.
they won't ask for. I mean, a roll-up
Right.
doesn't help them. Yeah.
Right, that's
Okay.
right.
Sorry, just one quick thing, Fred. I mean, I think post with DBSD and Yavich and stuff, there's been a lot of focus on absolute priority. So the extent to which you're not seeing roll-ups changing, maybe that's significant anyway, given the fact that absolute priority has become quite important in the case law. The fact that roll-ups, one might hope, one would the fact that they're still at the level that they are is significant because potentially one might see them decline to the extent that judges are looking to enforce absolute priority more squarely, as a matter of principle.
So you think judges care more about strict absolute priority now than they have in the past?
Well, I think the case law has been like, at least with DBSD and a little, in liquidation cases, that absolute priority is taken on greater salient. I mean, Chrysler notwithstanding, but so in that extent, with that in mind, maybe your finding is a little significant, if that makes any sense.
Yeah, that makes sense. Although, the DBSD kinds of cases are really typically smaller cases, where somebody who's got a stake in the equity is playing a game with the.
Sure. Yeah.
Follow up on another question. I wondered if the DIP and roll-up could have been. Do you know in the financial crisis were pre-petition lenders less likely to be DIP financiers? And you can imagine a world where, because liquidity is constrained, people don't have money to put in, so you have to get outside financing. Because you have to get outside financing, you see roll-ups go down.
Oh, so just compare pre-bankruptcy, post-bankruptcy DIP lending with the cases where the pre-bankruptcy lender wasn't able to.
Yeah, 'cause I'm
That's a
wondering
good.
if the roll-up, you're just catching an effect where during the crisis,
Right.
pre-bankruptcy lenders were like wrapped.
Right.
And so you were going to hedge funds.
Yeah,
Yeah,
no, that's a
yeah.
good idea. That's great.
That's
Thank
right.
you.
Okay, thanks very much. I think it was a very interesting session. Thanks to the discussants, Manish and Pratik as well. I think, like I mentioned in the beginning of this session, how these contracting arrangements evolve in India under the shadow of our new law, we should also, I think we should take guidance from, we should probably see how this literature applies to our context and see how it goes.